In the world of high-stakes lawsuits, overconfidence can be a lawyer's deadliest sin. Today, we're diving into a case that became a legendary cautionary tale in legal circles. A story where a simple settlement could have saved everything, but one lawyer's ego cost his client a fortune. Picture this: a bustling city, a thriving family-owned business. For decades, they had a solid handshake agreement with a major supplier. Everything ran smoothly until a new CEO took over the supplier company and decided to abruptly terminate their long-standing deal. The family was devastated. Their business was on the brink of collapse, so they did what anyone would do. They sued for breach of contract. They hired a lawyer known for his aggressive tactics and impressive win record. Let's call him Mr. Gable. From the very first meeting, Gable was the picture of confidence. He assured the family they had an open and shut case, painted a picture of a massive courtroom victory, complete with huge damages that would not only save their business, but make them wealthier than ever. The family, desperate and trusting, was completely sold on his vision. Before the trial, the supplier's legal team, perhaps sensing some weakness in their own position, offered a settlement. It was a substantial amount, enough to keep the family business afloat and help them transition to a new supplier. It was a lifeline. The family was inclined to take it. It was safe, it was secure, and it meant they could move on. The trial began, and initially, things seemed to be going Gable's way. He was charismatic in front of the jury, delivering powerful opening statements. But as the trial progressed, cracks started to appear. The supplier's defense team was sharp. They began to pick apart the case, focusing on one critical detail. The original agreement was never written down. It was a verbal contract, a gentleman's agreement made decades ago. Gable had built his entire strategy on the moral injustice of the situation, on the decades-long relationship. He assumed the jury would see it the same way, but the defense lawyers were masters of technicality. He argued that while the termination might seem unfair under the law, a verbal agreement of this nature wasn't as ironclad as Gable had led his clients to believe. They brought in experts who testified about industry standards and the legal requirements for long-term contracts.